Hi, everyone. This is Catherine. This is presentation three, legal analysis research. And for my research, I had, sucker punch. The facts were Jason and Mark were drinking. Jason dared Mark to punch him, stating, "I bet I can take it." Mark refused. Jason grabbed Mark's wrist and yanked Mark's arm towards his own stomach. Jason stated, "Come on, man, do it." Mark reluctantly pulled his arm away and punched Jason in the face. Jason's jaw was broken and teeth were knocked out as a result. Now, for my cases for consent withdrawn or exceeded, there were a lot of hits that I got for these case for this particular topic, but I just chose to narrow it down to two because of the time limit that we have. So I'll just breeze through the cases that I chose for both withdrawn and exceeded case for, consent and impaired consent, and then I'll go back and show you how I searched the case for the cases. So McNeil v. Brewer, consent was exceeded in this case. The plaintiff consented to being tested for the HPV virus once admitted and processed into Stateville Correctional Center in Illinois. However, the consent, there was initially, the plaintiff did give consent, but that was consent to undergo medical testing and procedures, basic standard testing that you would do when you're going to the jail or county prison or whatever, to see what diseases you have, to see if you're healthy, to see your mental health situation is, if you need medication, pills, or therapy or anything of that nature. However, the consent was exceeded due to the doctor using those same tests from inmates that are incoming and that have been there for a while in a medical study, that he didn't get consent from those inmates. He basically used the consent that they gave for the medical testing to see if they had the viruses. He used that consent to carry over to the medical study that he was conducting personally. And the plaintiff went and filed a complaint, one, and there with two issues within it. One was the violation of his Eighth Amendment, which was basically cruel and unusual punishment, and the second was the doctor was acting negligent in preventing the plaintiff from contracting the HPV virus or any other communicable diseases that were well known in the area that he was being processed in, which was the general population. The next case I have is People versus Prenzing. Consent was both withdrawn and exceeded in this case because as you can see here, a brief statement, the plaintiff initially consented to having personal computers and or laptops searched for credit card fraud. However, the real reason that the search was actually conducted was for child pornography. The detectives that came to the plaintiff's house were sent there based on a tip that they had received from the FBI, based on a certain number of people in that particular county of Illinois purchasing child pornography. But they used the reasoning of credit card fraud in order to get consent and to enter the plaintiff's house to search his computers. The consent was exceeded because while they were searching his computer, they began looking for certain images. Although they told him they were looking for Visa logo images, they were actually looking for child pornography images. And once they saw those images, they began to do a second investigation on the sites that those images were coming from. But they did not receive additional consent from the plaintiff to do that. And then eventually the plaintiff withdrew his consent after signing a document that he thought stated that he was allowing them to remove the computers and the laptops from his house, and so that they can finish the investigation that they were doing for the credit card fraud. And that's what happened. Now, for McNeil v. Brewer, the judges on this case for the appellate court, they affirmed some parts and reversed and remanded the other parts. They affirmed that they affirmed in the issue for the doctor acting in negligence because they felt as though the doctor couldn't have prevented that or something or another. And they reversed and remanded the issue about his Eighth Amendment right being violated. because he did not have any knowledge or didn't consent to the medical test study that the doctor was conducting. Now, for consent given while impaired. Sorry, I'm trying to hurry up and do this because my child is running around crazy in the house and I'm in the garage. But for the consent given while impaired, People versus Roden, the plaintiff gave defendant consent while impaired and intoxicated. Now, this case is a sexual assault case, which I really didn't want to do. I wanted to steer clear away from this type of case, because it's basically he say, she say type of testimony. But it was a really good case on consent while impaired, and the judgment by the appellate court was really surprising. So a little background on this story: both the plaintiff and the defendant. The plaintiff was, of course, a woman. The defendant was a male. They were both intoxicated. They were both drunk, and they both consented to consensual sex. However, eventually the plaintiff decided that she wanted to accuse the defendant of rape, and she went to the hospital, got the rape kit done, and everything like that. However, the defendant gave his testimony and stated that he had no knowledge that the plaintiff was unable to give or withdraw consent in the sexual acts, because he stated that while doing the sexual acts on her, she was not trying to remove him from her body. She was actually doing sexual acts herself. So he stated that he was unable to know and not have any knowledge of her being too impaired to withdraw consent. And because of this, the judges on this case decided to reverse the entire conviction of sexual assault that the defendant had been initially convicted of in the lower courts. And that was pretty much it, which was completely surprising because usually they don't reverse a conviction like that. But after reading the entire opinion, it basically gave the reason as to why they gave the conviction. They reversed the conviction, and I'll actually go back and show you guys how that came to be. And give me 1 second. That was People v. Roden. Okay, and here for People v. Roden, you have to go all the way down here at the bottom. Which I found really interesting as well in this case. Here you go. Like the court noted in Fisher right here, like the court noted in Fisher, under the facts of this case, defendant knew JT had consumed alcohol, but no evidence supports the conclusion that he knew that rather than simply having relaxed inhibitions, she was completely unable to consent. Thus, without more, this is insufficient to meet the state's burden of showing beyond a reasonable doubt that defendant knew that JT was incapable of giving knowing consent. We also observed that JT testified that her blood was drawn at the hospital. However, there was no further inquiry, wow, I can't talk, into whether the blood was used for a toxicology report or was drawn for another purpose. Notably, the state did not introduce any medical evidence that JT was in a blackout state as a result of her consumption of alcohol. Similarly, there was no medical evidence presented by the state regarding the physiology of alcohol consumption and how it may have been a factor in this case. And because of that, the appellate judges reversed the conviction of sexual assault, which is pretty freaking crazy. But smart as well on behalf of the defendant's lawyers, to indicate that in the appeal or whatever. Now I'm going to show you how I was able to search for this case. If my laptop will let that happen. As you can see, I'm approaching free recording limit. So I will probably just have to just put it in the discussion post itself on how I was able to get to this. Like for the People v. Roden, I was able to go to the key number 424, necessity of waiver or consent. And as you can see, a lot of cases pop up.